Honorable Chief Justice and Justice of the Supreme Court of Ohio. The Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning. Good morning, ladies and gentlemen. Our first case this morning is 20-407, In Re Judicial Campaign Complaint against Karen Coppage-Falter.
May it please the court. My name is Donald Bry.
Okay, Mr. Bry, would you wait a minute, please?
I apologize.
That's okay. I'd just like to draw your attention that we have three appellate judges who are taking the place of three of our justices. We have Judge Michael Hall, Judge Sean Gallagher, and Judge Stephen Powell. Welcome, gentlemen, and thank you for your service this morning. Okay, now we will start with Mr. Bry.
May it please the court. My name is Don Bry. I'm counsel for the respondent in this matter, Karen Falter. And this case calls upon the court to clearly state whether Canon Rule 4.3a of the Code of Judicial Canons incorporates the New York Times Sullivan line of cases regarding knowing or reckless disregard or not. If that standard applies, which is not just the New York Times Sullivan case, it's also the other cases that flow from it that we quoted in that brief, the Republican Party versus White case, the Williams-Yulee case, the Winter v. Walnut-Zet case, that say that when you're dealing with certain types of speech, you either have to know that it's false or act with reckless disregard of its truth or falsity, which means have a high degree of awareness of its probable falsity, and that sort of thing. There are a number of ways of describing it. If that standard applies, it is clear that the adverse finding against Ms. Falter should be reversed. Even the panel below at page 3 of their order indicated some concern that if they were to apply that standard, they would have to make no findings against her. And expressly at the bottom of page 2 of their order, rejected the New York Times Sullivan standard, as did the initial hearing panel. There is no evidence in the record, let alone clear and compelling evidence, which is the requirement of proof, that Ms. Falter said anything in her February 13 letter that went out to 202 households, other than what she believed to be true. The language in the letter was reviewed in writing by her campaign consultants, the same campaign consultants who had represented her opponent, Kurt Hartman, and presumably in 2 years earlier, in 2018, and presumably knew, or she presumed that they knew, when Kurt Hartman had moved from Claremont County into Hamilton County. They reviewed that letter, they told her it was fine, and she sent it up. Shortly thereafter, she found out that the statement of when he had moved there was false, and wrote a retraction that was sent out within days. According to the transcript, page 124, the original letter was sent out February 13, and the retraction was sent out February 19. I believe there's an error in opposing counsel's brief stating there's nothing in the record about that. There is. There is conflicting testimony about whether or not the original time period of his move into Hamilton County came from her campaign consultant. She said it clearly did. One of her campaign consultants says they talked about some dates, but he wasn't sure they pinned it down. There is some dispute in the record about whether or not the campaign consultants thought that they were going to review things initiated from her for accuracy. But in fact, the undisputed evidence is they did exactly that just a month prior to another matter that was initiated by her. And the standard...
Counsel, may I ask you a question?
Yes,
you say that the way that your client found out about the information was through her campaign consultants.
Yes,
I thought her testimony was also that it was common gossip around the courthouse and that she would have had knowledge of it that way as well.
Well, I asked her that question directly, whether she relied upon the common gossip around the courthouse or relied upon her campaign counsel. And her testimony was she did not rely upon the common gossip, and she did rely upon her campaign counsel. The purpose of our presented evidence about the scuttlebutt was that she didn't have reason to question what she had received from her campaign consultants. In other words, if her campaign consultants told her one thing, everybody else was saying that's not the case, she would look into it further.
Well, isn't this case about that our rule of conduct as judge candidates is that we do have cause to question rather than just accept rumor as truth?
Well, it's not rumor if in fact she's relying upon a campaign counsel to actually work for the guy, but the rule itself is formed in the form of the New York Times Sullivan Standard. As a matter of fact, Rule 4.3a is modeled upon a statute that was formerly used in the Ohio Elections Commission. The Ohio Elections Commission lacks jurisdiction, but this court still does have jurisdiction over judicial false statements. And so it's not a matter of, frankly, there are some cases that state that relying upon rumor, if you believe it, is adequate, but that's not what she did. She didn't rely upon rumor. She relied upon her consultants. She sent it to her consultants. She asked her consultants to review it, and that's all in writing. Her consultants did review it. Her consultants told her that the letter was fine, and she sent it out. And I realize that there are some statements in the decision below that said she just relied upon rumors and innuendo. But that is not what the evidence of the record says.
But Counselor, if we accept your argument, wouldn't that allow all judicial candidates to have their campaign committees give them whatever information that they think is beneficial to the campaign, and allow the judicial candidate to be free from having to answer to any falsehoods that are published?
No, it would not, although that deals with Rule 4.2 more than 4.3. Rule 4.2, which she was not charged with violating, requires a candidate to review and approve all of the messaging of a candidate's campaign. And so you can't avoid culpability for knowing misstatements of your campaign by saying you never read them. At the same time, if you have someone in your campaign who is responsible for saying this person moved into Ohio on this date, you don't necessarily have a duty to do your own background research on that, if it's, in particular, if it's coming from what you believe to be a reputable source.
Counsel, what was the relevance of this information that she ultimately decided to put in her letter? What was her purpose in saying that this person hadn't moved into the community until such and such a date, regardless of whether it was correct or not?
Mm-hmm. Her testimony was that Cincinnati is a fairly proud town that values long contacts with the community, with the Hamilton County community. And her campaign consultants had recommended several times, according to her testimony, that she emphasize her family's longstanding connections to Hamilton County, and contrast that to the relatively recent move of her opponent into Hamilton County, which by his own testimony was obviously not to obtain a judicial appointment that didn't come up until a couple years later. But he testified that he did move into Hamilton County in order to pursue better political opportunities than he had had in Claymont County. So
it had nothing to do with his qualifications to serve in the position, correct?
Well, if you're talking about years of service, and no one was saying that he was an unqualified candidate or that his petition should be rejected, but the voters have the right to determine what qualifications they believe to be important. And she believed that the voters would find the desire to have someone who has longstanding connections to the community to be a qualification, which not a legal one, is one that they would find to be important.
Well, if you're going to characterize someone as an outsider to gain an advantage in your campaign, don't you think there's a higher obligation to make sure you have your facts straight before you do that?
Well, obviously, that's what the panel below said. It had sort of a negligence standard or some other sort of standard about that. The problem is twofold. One, that's not how the rule's written. And two, the courts have held that you're not allowed to write rules that way. I referenced, for example, the Winter v. Wallace Sixth Circuit case, 2016, which upheld the right of Kentucky's bar to enforce a rule substantially identical to 4.3a. But they enforced it because it only prohibited known falsehoods. Instead, quote, only a ban on conscious falsehoods satisfies strict scrutiny. And indeed, this court has held a couple of years earlier in the O'Toole case, basically the same thing when it said that erroneous statements are inevitable in free debate, must be protected if the freedoms of expression and to have the breathing space they need to survive. That's in the O'Toole case.
Well, but Counselor, does it matter is there a difference between something that might be said in debate between two candidates without the opportunity, the time to check? Should it matter here that there was a time lag, there was enough time to verify the information? And should it matter that the information was relatively easy to verify?
It was relatively easy to verify, and she presumed that her campaign consultants had done that. That was why she sent the written letter to her campaign consultants to review and approve. But in terms of the timing, no, I don't think there's a constitutional difference.
Well, when you said she assumed that they verified it, what evidence was there of that?
Well, Exhibit B to the transcript shows that there was a email chain back and forth, and that they ultimately said, go ahead and send the letter out. So that was in the evidence. It wasn't disputed.
But was it that she said, was this information verified? Did you double check it? Are we sure that this is accurate?
Well, her testimony was that she took the information that they had provided to her about the dates. Obviously, there's a dispute about that. But that was her testimony. And therefore, she said, this is what we've written, that they had encouraged her to write something along those lines. What do you think? Is this okay to do? Now, did she say check it for facts? I don't think in those words, but they had checked for facts what she had sent them the prior month that also had initiated from hers. And she was presuming, reasonably, I would suggest, that they were doing the same thing.
She didn't ask, how do you know that he moved here on such and such a date? What do the property records show? I mean, she didn't ask them to give her a comfort level that they did due diligence in verifying the information that was pretty central to the message she was delivering.
Your Honor, the individual she was vetting it from had represented Kurt Hartman in his 2018 campaign to retain the seat to which he had been appointed in 2017. They were not strangers to Kurt Hartman or to his background or to his biography. So her reliance upon these particular individuals is rather different than relying upon somebody in the street who says, oh, I think somebody moved here 3 years ago.
But Counselor, that's like saying, and I understand what you're saying. These weren't strangers. These were appropriate people who were working for her, being paid for her, and who had some familiarity with Mr. Hartman. But, that's like saying, a judge with 30 years experience can never be wrong.
Well, judges with 30 years experience and lawyers with 30 years experience can be wrong. But as this court has said, erroneous statements, wrong statements are inevitable if we're going to protect free debate. And it's not just this court. The Sixth Circuit has said that. The U.S. Supreme Court has said that. And that's pretty clear. Yes, judicial campaigns do not need to be conducted in exactly the same way as non-judicial campaigns. And there are a number of exceptions to that, but strict scrutiny still applies. And you have to have a compelling interest and a narrowly tailored rule that applies to that. So, for example, you can and do prohibit judges from personally soliciting money and from personally endorsing other candidates, although they're allowed to announce views since the White case on undisputed matters. But in terms of the core communication, the standard that this court stated in O'Toole, the standard that the Sixth Circuit stated in Williams-Yulee says that even though we might think that it should happen, that they ought to know that they should take greater care, the penalty for not taking greater care is the penalty that my client suffered. Namely, she was humiliated. She had to confess to people that she had made a false statement about her opponent. She lost her primarily badly. She was accused in the press and otherwise of being a liar, and to add discipline on top of that, I think ignores the fact that the free and full exchange of debate seems to have corrected any momentary harm that might have been caused by that letter to 202 households that was retracted within a week.
Would it be any different if she won her race?
I'm sorry, Your Honor, I didn't hear your question.
Well, you pointed out that she lost the primary, but in terms of reckless, relying on courthouse gossip, I mean, would the facts be, would the conclusions be any different on whether or not she should be held responsible for a violation if she won her primary?
No, they're talking about losing the primary is talking about how the statements by various courts that the free and robust debate causes more speech to cure the problem of erroneous speech. I don't think, well, first of all, obviously I've disagreed, and we can go around about whether or not she relied upon courtroom gossip. She said she didn't. The panel said we think she did. Presumably, presumably what they meant was she relied upon her consultants and they were just relying upon courthouse gossip. I don't know. But had she relied upon courthouse gossip or some guy in the street saying, hey, you know, this, that, the other thing, you would ask yourself the two questions. One, did she know that it was false? And two, did she speak with a high degree of awareness of its probable falsity? I would think that there are circumstances under which if somebody just tells you something off the street that sounds too good not to be true, you got to check it. I see that my time has expired. I'm willing to keep talking, but I don't want to abuse it.
Okay. Are there any other questions for Mr. Bray? Okay. Thank you, counsel.
Thank you, Your Honor.
We'll take the matter under advisement. You'll be notified of our decision.
Thank you.
Our second case this morning is 2020-134, John S. O'Keefe et al. Versus Jeffrey A. McLean, Tax Commissioner of Ohio et al. For the appellants, Ms. Dickinson. You'll have to unmute you. There you go.
Yes, I got it. Thank you. Chief Justice, Your Honors, and may it please the court, I'm Dr. Sandra Dickinson, attorney for appellant John O'Keefe. I would like to reserve 4 minutes of my time for rebuttal. This complaint against continued property tax exemption is about property operated as a public airport by a state university. The BTA decision below that the entire OSU airport property continues to be exempt under RC 334517 is unreasonable and unlawful and should be reversed and remanded for split listing under RC 571304 because this complaint against continued exemption should be properly reviewed in terms of material change in operational use since the exemption was originally granted, in accord with this court's precedent and the tax commissioner's procedures. In 1943, when the exemption was originally granted, OSU Airport was operated as a private facility exclusively used for its flight training program, as required by any exemption statute available at that time. There is no dispute that OSU Airport was not originally exempted under 334517 for the simple reason that statute was not enacted back then. After OSU Airport became a public airport in the 1960s, the operational use of the property has changed so much that it no longer even meets this court's primary secondary use test under 334517 for a small part of state university property used to produce income. By 2016, when this complaint was filed, OSU Airport was ranked as the third busiest public airport in Ohio. 82% of OSU Airport income is produced from its public, non-university users. And none of OSU Airport income since 2006 can any longer be deposited into the University General Fund to support university activities. And still, the only academic program actually conducted on OSU Airport property is flight training. The tax commissioner and the VTA below bypassed both these tests by finding a synergistic relationship between the public non-university uses and the educational uses support the university. However, synergistic relationship is not what this court meant by used in a way that operationally relates to some degree to university activities. And this court has expressly rejected the synergy rationale for other public airports in Ohio and applied split listing.
Well, don't all the profits, any income derived from the airport go back into the airport?
The profit, the income produced, all the income produced by OSU Airport must be used.
So the income must be used. Okay, the income must be any income must be used per the FAA for the airport, and the airport provides some benefit to Ohio State. So why isn't that enough under the statute?
It's, I think, a circular argument, because the second component of it, that the airport, even in part, supports the university, is the the exact thing that's being contested. How is the airport, is even part of the airport supportive of the university, and how that relationship between an income that can only be used to support the airport.
Well, do other airports, other public airports in Ohio pay taxes?
Yes.
But counsel, my understanding is that the money that is generated goes back to the maintenance of the entire operation of the airport, and the university and their engineering department and other components utilize that airport, and thus it defrays the cost for the university. Is that not accurate?
Yes, it's accurate. The defrayal of the cost is that is the kind of thing that I don't believe this court meant by operationally used to support the university.
Well, if the university doesn't have to expend funds, then, and those funds can be diverted for other, operations of the university, and there's a benefit to the university community, in other words, the students, why is that not sufficient?
The use of income itself, in accord with this court's precedent, is the use of income alone is not enough. It's the operational use, not the use of the income, that creates the exemption.
Would you explain that a little further? I don't know that I understand.
The key case in that regard is the Columbus City School Board versus Testa, decided in 2011. And I will refer to it as Testa. Testa said that the principle to be derived from Kinney and Limbach, which were two previous cases, is that ancillary use of property that generates income does not defeat exemption as long as the property is used to some degree, either currently or prospectively, in a way that operationally relates to university activities. So the use of income by itself is not enough.
But doesn't the operation of the airport relate then to the a useful, it's a useful asset to the airport, I mean, to the university? The fact that that airport is operational, is self-sufficient, and requires no contribution from Ohio State, and yet Ohio State derives a benefit, is that not sufficient?
I don't believe that's what this court meant in Testa. This court in Testa specifically said that the statute 334517 subordinates the concept of support to the concept of use. So it's the operational use of the airport that must support the university's educational activities. And this complaint specifically asked that either all or part of the property no longer continue to be exempt, because the majority of the property is not used for exempt purposes under Testa. It's used to produce income. Now, at the same time, the court in Testa specifically pointed out that the two previous cases, Kinney and Limbach, in both of those cases, one of the key elements was the deposit of the rental income into the university general fund to be used for other general university activities. Now, in this case, the income can only be used for airport operations. So none of the use of the income for OSU airport doesn't comply with either Kinney or Limbach or Testa. The court in Testa said, however, with respect to the deposit of income produced into the general fund, the court in Testa said the use of rental income for support of the university as deposited into the university general fund was a key element in each of those two previous cases, so that the use of income to support university activities, whenever there is any such income, is probably a necessary condition for exemption. And in this case, since 2006, none of the OSU airport income can any longer be deposited into the university general fund to support university activities. There was, the way the BTA described it was that there was a synergistic relationship between the public non-university income producing uses and the educational uses that supported the university. And in neither Kinney nor Limbach, was there any discussion about anything remotely like synergy between the income producing uses and the educational uses that supported the university? The concept of synergy is not what this court meant in any of its other 34517 cases.
Ms. Dickinson, you have about 2.5 minutes left. Would you like to reserve that for your rebuttal?
Yes, thank you.
Thank you. All right. Is Miss Allison? No, excuse me. Miss Houston is going first.
Thank you. Chief Justice and Justices of the Ohio Supreme Court, may it please the court. My name is Hillary Houston with Rory, Sater, Seymour, and Pease, representing the appellee, the Ohio State University. At this time, I would like to reserve 2 minutes of my time for counsel for appellee, the Ohio Tax Commissioner. The Ohio State University Airport has been exempt from real property taxation for more than 75 years. However, today, John O'Keefe, the appellant, is asking this court to revoke that tax exemption. This despite the fact that over the years, the Ohio Tax Commissioner, the Ohio Board of Tax Appeals, and yes, even this court have reviewed the Ohio State Airport's real property tax exempt status, and all have found the airport to be used in support of the university and exempt from real property taxation. Ohio State's tax exemption is reviewed under Ohio Revised Code section 334517. This is the statute that appellant cited to in his complaint against continuing exemption, and that the tax commissioner reviewed and found Ohio State's airport satisfied. This is the statute that appellant cited to in his notice of appeal to the Board of Tax Appeals, and the statute the Board of Tax Appeals reviewed in affirming the tax commissioner's decision. We shouldn't look to other statutes to determine the real property tax exemption for the airport. The only statute at issue today is 334517. This statute allows real property tax exemption for state university property that is used in support of state universities. The statute has two requirements. First, the property must be university property. Here, the airport is owned by the state of Ohio for the use and benefit of the Ohio State University. Thus, consistent with the BTA's decision below, the first requirement, the ownership requirement, is satisfied. Second, 334517 requires that the use be used, or that the property be used in support of the university. The court has addressed this use requirement in at least 3 separate cases, 2 of which involve the Ohio State University, and one of those 2 cases involved the Ohio State Airport itself. In Board of Trustees v. Kenny, this court reviewed the Ohio State Airport and found that the overall use of the airport was to, quote, further teaching and research in aviation, unquote, and that other users at the airport did not defeat exemption under 334517. Later, this court in University of Cincinnati v. Limbach affirmed the plain reading of 334517 and held that the university property there that was used or planned to be used for some expanded university facilities satisfied the use requirement despite the fact that portions of the property there were being leased to private parties. Most recently, in Columbus City School District Board of Education v. Testa, this court held that to satisfy the use requirement under 334517, the use must be operationally related to the university, meaning the actual use of the property must be tied to university functions or activities. The court further held that it's not enough to simply satisfy this requirement by using income or using the proceeds from income producing properties to financially support the university in general. There needs to be more. In that case, the court denied real property tax exemption under 334517 for McDonald's, among other things, not because of the existence of a lease or a third-party user, but because of insufficient evidence to show the operational relationship between the McDonald's property and the university. Here, the airport is related to the university because it is the university and it's under Ohio State's College of Engineering, and it's used specifically for educational and research purposes. Appellant would have this court believe that Ohio State only uses this airport for its flight education program. In brief, he dismisses all other uses as simply student visits. This couldn't be further from the truth. The Ohio State Airport is one of 30 university-owned airports in the country, with at least 2 other state university airports located right here in Ohio. The Ohio State Airport is one of the university's core facilities. Again, it's part of the College of Engineering, and it serves as a learning laboratory that supports more than 30 degree programs. This includes bachelor, master, and PhD programs. The airport is operated and managed by Ohio State students, faculty, and staff, and it's used specifically for courses like airport management, planning and design, aeronautical, mechanical, and civil engineering, architecture, industrial design, and finance, just to name a few. As the director of the airport testified below at the BTA, the airport provides Ohio State students with the very best education possible by allowing its students, quote, firsthand contact with the things they're learning in the classroom, where the practice of the industry meets the theory of the classroom. Ohio State also uses the airport for research and has 2 research facilities located at the airport, the Gas Turbine Lab and the Aerospace Research Center. These facilities are using the functioning airport to conduct research, which allows Ohio State students, its faculty and staff to collaborate with universities as well as government and corporate partners. Ohio State's aviation program is also based at the airport, and it is recognized as a center of excellence for general aviation safety, which then allows for FAA-funded research in areas of safety and lighting issues at the airport. Ohio State also uses the airport for various community engagement activities, and these include K-12 student field trips, aviation and space camps, training exercises, and as a drop zone for the U.S. Army. Finally, as appellant has recognized here today, the airport is also used for flight education. However, appellant's focus on this one use at the airport and then all of the percentages and the ratios that he derives is extremely misleading. Looking only at the flight education program, he's arguing for a split listing that is nonsensical. In brief, he actually suggests that only 2,000 feet of one runway and 500 feet of another runway should be granted exemption. And that's worth repeating. He's actually asking this court to grant only portions of the runway an exemption, because based upon what he sees as the only use, the flight education program, that's all that's necessary. And
Counselor,
even putting aside for a minute all of the other.
Counselor,
Yes.
let me ask you a question. Do we know, or is there any evidence that Ohio State would continue to use the airport or operate the airport if there were no educational purpose associated with it?
That is the whole reason for the airport, that it is, because it is part of the College of Engineering. It's under the university, and that's the purpose that it would be, that it's used for teaching.
Well, I understand that, but I'm saying based on how it has evolved over the years and the use of the airport by private sector, by private industry, would it continue to operate if it had no educational, if the educational purposes ceased?
I don't think I'm in a position to answer that.
Okay.
I would just be guessing at this point, really. I would just point you back to how it's been used.
No, I was wondering if you had any information that indicated that based on the revenue stream produced from its from the use. But if you don't have that information, that's fine.
No, it's been operated in this way for more than 75 years, so it's hard to imagine it being operated in any other way.
Counsel, did I read that the airport is not operating in fact, it's operating at a loss?
Yes, Your Honor. So the funds that the FAA requires a number of things, and one of those is that the airport be operated as self-sufficiently as possible financially. So any income that is generated goes into this airport fund. But again, that airport fund is a university fund because the airport is part of the university. But even with all of that and with the income being generated and used for operations, it's still operating at a loss. So year after year after year, the university is actually forced to pull from other university resources to actually fund the airport.
Counsel, in the evidence, is there any showing that any of the buildings, office space, I was trying to read the evidence and it wasn't easy to understand sometimes. And some of the buildings have like research facilities in it, things like that, classrooms. Are there any buildings in which OSU does not have classrooms, research facilities, and it's just leasing it out to private people?
I'm not aware of the makeup of the university as far as being able to point to where all those courses are take place at the airport. But even when you're looking at a hangar,
I'm not talking about a hangar. I'm talking about office space.
I'm not aware of any office space that would be there. The university has some academic office spaces. If there's any office space that's leased out to other third parties, those third parties are there because Ohio State needs them there, and and all those third parties are there in order to support the mission of Ohio State.
And what's the evidence of that? Is that in the record?
I believe there's some leases in the record with regard to any third-party users there. I'm not sure if there's any evidence in the record as far as where each course is located within the university. But what the university is trying to do and has done successfully with this airport is to set it up as a teaching airport. So it's not that only this piece of the airport where the classroom is located should be exempt. In order for all those courses to fully support and all the degree programs to use the airport, it has to be the airport as a whole. If you start looking and start trying to piece out and take out different areas of the airport, I think you're essentially applying an exclusive use requirement, and 3345-17 doesn't have that, and it was intentional with regard to what the legislature enacted on this statute. But going back to the statute, the split listing percentage, and I touched on this a little bit before, the split listing percentage that is being offered by the appellant really would require this court to ignore the other uses, and would require this court to ignore the fact that the airport is operated as a whole. And when you look at the requirements of 3345-17, there's just two requirements. It's ownership and then it's use. And the BTA made this factual finding below that it is operated as a whole and is operationally related to the university, and thus it qualifies under 3345-17. So if you start trying to pull pieces and parts out, again, I think you're trying to put words into the statute that just simply do not exist.
But Ms. Houston, Worthington Industries and Cardinal Health, what do they contribute to the academic program of the university? They have large hangars and office space.
In order for the Ohio State University to use the airport, it needs to be both FAA regulated and full service. So having those users there, which are general aviation users, is one of those requirements. It's absolutely necessary to have them there. So it's not that the aviation users.
You're talking about income. How could that possibly contribute to the academic pursuits of the university?
It's just not the income. The FAA, in fact, requires that the airport be made available to all general aviation users. So it's important that they have to be there. If they don't have the general aviation users there, they can't be full service and they can't be FAA regulated. And the Ohio State University is relying upon both of those in order to fully utilize the airport.
But how are the FAA requirements critical to the academic pursuits of the university?
Without the FAA, the airport would not be able to function from the standpoint that you don't have, the university would lose certain things. They would lose their air traffic control tower. They would lose their advanced landing and communication systems. And Ohio State is using those items, among other things, for its degree programs and for its research. Those things would not be possible without that FAA designation.
So students actually get internships or something doing air traffic controlling? I can't imagine that they would.
We actually, the Ohio State students, remember going back to the coursework, it's airport management, planning and design, among other things. So they're involved in the management and operations of the airport. So they're just not casual observers. They're there operating the airport. So you need those things, not just for the flight education, because obviously it can't be a functioning airport without some of those things, but you can't have those courses utilizing the airport.
Counsel, you're into your co-counsel's time considerably.
Yes. At this time, Ohio State would just like to recognize that the airport has evolved over the last 75 years, but it continues to be used for university purposes, and we respectfully request this court to affirm the BTA decision. Thank you.
Thank you. Ms. Allison.
Good morning. May it please the court. My name is Kim Ellison, and I'm here on behalf of the Appellate Tax Commissioner. 334517 is clear and unambiguous. The sole requirement for university property to be exempt is that it be used for the support of the university. And in my limited time, I would just like to request that the court affirm the BTA decision for 3 reasons. First, change in use in exempt property is irrelevant so long as the property continues to be used in an exempt manner. Second, appellant's reliance upon this court's decisions in Perk and Vic is misplaced because both of those cases involved exemption under statutes that require exclusive use of the property for the exempt purpose. And third, the commissioner's review of complaints against continued exemption is clearly not limited to the statute under which the original exemption was granted, but rather the commissioner reviews the complaint to determine whether the property is exempt under any statute in the revised code. In this case, appellant relies upon inapplicable statutes and misinterpretations of the law to try to impose additional use requirements that are simply not present in 334517. First, because the airport property has continuously been used to support the university, change in use is irrelevant. In Vic, the court did not hold that any material change in use would defeat the exemption, but rather that the complainant was required to prove a change from an exempt use to a non-exempt use. Second, as I mentioned, the court's decisions in Vic and Perk are inapplicable because they relied upon much more restrictive exemption statutes. In Perk, the court considered whether a municipal airport, not a university airport like the Ohio State Airport, but whether a municipal airport was exempt under 570908. And that requires property to be used exclusively for a public purpose. In Vic, the court considered exemption under 570912, which required exclusive use for charitable purposes. Again, there's simply no exclusivity requirement in 334517. The commissioner respectfully requests that the court affirm the BTA's decision. Thank you.
Question for you. Did the tax commissioner consider split listing? And if so, why was it rejected?
The split listing is inappropriate in this case because there's simply no proof to support it. First of all, as Ms. Houston pointed out, the airport itself is a system. Without the entire, it's kind of a learning laboratory. Without having the entire property, then it would not function as the same system and not provide the same opportunity to the students that it provides. Further, if split listing were appropriate, the burden is on the appellant to prove it, and there's simply no evidence to support any type of split listing. This court has never agreed.
I thought that the burden is on the property owner to prove the tax exemption now.
So as the complainant, Mr. O'Keefe filed the complaint against continued exemption. So the burden is actually on him to prove that the property is no longer being used in an exempt manner. I mean, when the commissioner receives the complaints, he kind of treats it as an inverted exemption. So he notifies the property owner and he gives them an opportunity also to present evidence. So it's kind of a 2-in-1. But technically, as the complainant, the burden falls squarely upon the appellant.
And that's because you already have the exemption.
Exactly.
In order to take the exemption away is different than establishing the exemption to begin with.
That's exactly right, Your Honor.
You say exclusivity doesn't matter, and I agree that word's not in the statute. But 334517 says all property used. So let's say you have a dorm and it's got 200 rooms. Only 3 of those rooms are used for student housing. they rent all the other rooms out to travelers. Are you saying that the dorm therefore still meets that property exemption because you're still using only 3 of those rooms for students?
Well, that is a completely different scenario. I think then you get into the court's analysis in the McDonald's case. Here, I mean, the entire property is used as the learning laboratory. The entire property.
You say that, but when you look at the map that OSU gave in relationship to a public records request, you see a map that really designates student areas versus private areas. There's no admittance to the hangars of these corporations. They have a separate ramp for your private users of your largest users: Time Warner, LabCorp, Myers, Worthington Steel. And then you have a separate ramp only for students. And students only have access to that portion of the airport. So how is that any different than the dormitory?
Well, first, the BTA previously considered the hangars and found that they were exempt under 3345-17. They followed this court's guidance in refusing to narrow the definition of support. So, and
Kinney was decided in 1992. Kinney was decided in 1992.
Correct.
The map of the airport, the foot plant, all of the ramps, the runways, it's not the same as it is today. You've added runways for private use only to allow larger jets to land and be stored by corporations. How does that, how are those pieces of property still being used by the university?
Well, first, I'm not aware of any case where a split listing has ever been granted based upon a percentage of use. And I'm not sure how the commissioner would grant an exemption for half of a runway. And second, I would just go back to the fact that 3345-17 does not include the exclusivity requirement, and the General Assembly clearly made that decision not to include it when it included it in other sections. It's a much more broad application.
Well, counsel, I thought I heard your co-counsel say that in order to have a airport management degree program, the FAA requires that facet of the operation to be a full service. And isn't that what we're talking about here?
Yes, that's correct. I mean, as I said before, it's the entire system is a learning laboratory. Students come to Ohio State, they can take these programs and they can get the experience of actually, you know, with a control tower and the multiple runways, experiences that they can't get anywhere else, that they clearly operationally relate to the operation of the university.
But could a university buy a shopping center and get it exempted as part of its program to teach business management?
Well, I mean, clearly you'd have to look at the facts of, I think those would be different facts. I mean, I think that a learning laboratory like an airport is something different. There's really nowhere else you can get the same experience as you can from learning in a fully functioning airport.
Okay, thank you. Here's your time.
Thanks.
Ms. Dickinson, I believe you have a little over 2 minutes. We'll see what the clock says. Yes, 2 minutes and 12 seconds.
Thank you. Thank you, Chief Justice. I'd like to make a few points here in my 2 minutes. That Ms. Houston has said that other cases have affirmed OSU's exemption under 334517, but that is not really accurate. None of those cases was about this OSU airport parcel at issue. Indeed, even the BTA 1992 case about Worthington Industry Hangar was limited to only 0.75 acres out of all 325 acres of this parcel. And this court did not have the opportunity to review that decision, was not appealed. So there hasn't been any other case that affirmed this parcel's exemption. And I would also like to point out that the Vic versus Cleveland Memorial Medical Foundation specifically said it was looking for evidence to show the hospital was being operated in a substantially different manner from the manner in which it was operated in 1949 when the exemption was first granted. Any exemption statute available in 1943 for the airport property required two things: exclusive use and not with a view to profit. Vic was looking for ratio-based evidence in that case, what the ratio was between paying and non-paying patients. Now, in this case, appellant has demonstrated the percentage of OSU airport property that is used to produce income. And the sources of OSU's percentage use evidence can be used at the same sources for a foundation of the kind of square footage or acreage that is needed to separate the airport into the parts of the property that are exclusively used for educational exempt purposes and the parts that are used for non-exempt purposes to produce income.
Counsel, does it matter that there is a loss demonstrated at the airport?
The word profit in these statutes doesn't mean make more money than you spend. It just means make money.
Well, where's the definition of profit that says that? Is that defined in the statute?
Well, no. The word profit is not defined in the statute, but there have been other cases that have come to that conclusion that the use of the word profit in these statutes doesn't mean make more money than you spend. And I unfortunately can't cite one in particular.
Okay, I didn't think I read that, but okay. All right.
Counsel, one other question. Counsel, your colleagues on the other side say that Mr. O'Keefe has the burden in this case. Any response to that?
I think that's an inaccurate interpretation of 5.7.
I mean 5715.17.
Yes, it expressly states that the property owner has the burden, and it also expressly states that the fact that a property was previously exempt is not evidence that it continues to be exempt. And in the tax commissioner's procedure, DTE 103, the tax commissioner expressly says that a complaint against continuing exemption is to be reviewed under the same policies and standards and procedures as an application, which would require the burden on the property owner to demonstrate it continues to qualify for exemption in the same way as an applicant.
Thank you.
Thank you. Okay, we will take the matter under advisement, counsel, and you'll be notified of our decision. Marcia, we call a recess, please.
The court will now take a 10-minute recess.
Thank you.
Our third case this morning is 2020-244, W. Randall Erickson et al. Versus Paul E. Morrison et al. For the appellant, we have Mr. John Brody.
Chief Justice, may it please the court. Indeed, I am John Brody of Kegler, Brown, Hill, and Ritter, attorneys for the appellants. I wish to reserve 4 minutes for rebuttal. The Marketable Title Act says that an owner of land has marketable title if the chain of title remains unbroken for 40 years. But if within that 40-year period, the title shows a sufficient reference to a property interest that predates the root of title, well, that old interest is preserved. In the 1949 root of title deed here, there is a reference to a reservation of coal, gas, and oil. There's no question, no dispute that this description is accurate and free of ambiguity in the sense that it is a particular property interest that has been described. A mineral interest, a fee mineral interest. Now that reservation was repeated verbatim in the deed to the Morrisons, the appellees, and recorded within the 40 years. And that reservation was repeated verbatim in a deed from the Morrisons to themselves, again within the 40 years. The question here today is that reference, that reservation that was repeated, sufficient to preserve the mineral fee interest and not extinguish it under the Marketable Title Act? There's no dispute about the extent of what is set forth in the reservation. There's no names, parties of the first part, to the extent you could call that a name. There's no volume and page within the reservation. There is, however, an accurate description of the property interest. Now, the Morrisons argue that my client, the Ogle heirs, the Ericksons, that this mineral fee interest has been extinguished due to the 40-year statute of limitations. Our position is that under Blackstone and Toth, that the interest is preserved. The three-part test of Blackstone, we need to deal with two of those parts, but not the third. I'll get into that here more. First prong is the interest described? Second, is the reference a general reference or not? That's important. Is the reference a general reference or not? Third test is, if it is general, then are there specific identification that can be found? In our case, the interest is unquestionably described. We have met the first prong. The second prong is it or is it not a general reference? Our position is, under Blackstone and Toth, it is not a general reference, that it is a specific enough, particularized enough reference that it is not a general reference. And once this court would determine it's not a general reference, it's the end of the discussion. The interest would be preserved and not extinguished. So why is this reference not a general reference? Again, the interest, the reference is accurately describing a particular property interest, a mineral fee interest, coal, gas.
Is the interest accurate in the subsequent deeds? You have the said first party language, which is really either nonsensical or refers to someone other than the original grantor. I mean, when you look at those subsequent deeds and it says said first party, how does someone know what that means?
How someone would know what that means is by tracking back into time. It is a reference that is indeed repeated. That is not uncommon in this world of title, in particular in title with oil and gas, to have that. Indeed, it does create a question as to who those first parties are. The primary focus, though, is whether or not the interest itself is accurately described. And indeed, that interest, coal, gas, oil, is sufficiently described. And another way, Your Honor, to figure out what's general and what's specific is to look at the kinds of sort of this range of descriptions that can find their way into these kinds of deeds. One is, on the one hand, something that's got volume and page and names, and another is, on the more generalized basis, subject to all reservations of record, or something like that, that is so much more general. So those kinds of that kind of language, subject to all reservations of record, or subject to easements and use restrictions of record, that kind of language finds its way into any number of deeds and legal instruments that have been filed of record. And it's that sort of language that is, I contend, general. But what we have here is a description of coal, gas, and oil that is a particular description and sufficient. And why can I have this conviction? It's because of these two key cases, Toth and Blackstone. Toth came first, of course. The reference was to setback use restrictions. The deed accurately described the restrictions. There was no name in the muniments, no volume and page in the muniments, and this court found that the reference was sufficient. It's not a general reference, and found that it was not a general reference, and therefore it was preserved. Now, there was a plat that did have a volume and page, but that plat was not one of the deeds. It was not a muniment under the statute upon which there could be a reliance that the reference was sufficient. And for that matter, the volume and page was not referred to by this court. So the bottom line in Toth was a volume and page was not the basis of the decision on which
Counsel, excuse me, are you saying that because you can go back and research who the first parties referred to when that, the mineral rights were first present in whatever the deed or transaction was at the time, in that original document, is first parties defined? Are they named?
Short answer is yes. If you go back to the where the title got severed between the surface and minerals back in 1926, those parties are identified. And it's not a heavy lift to go back from 1949 to 1926 and to 1926. It's really one step in the process.
But that's this case. I mean, you could have other cases where it could be, much farther you have to go back. I mean, so I'm not sure that proves all that much.
Well, a couple of things. It is indeed true that there are so many variations on a theme that you cannot develop a bright line test, nor could you develop something that would encompass all of the kinds of examples that could become before this court.
Isn't the point of the rule to allow someone to be able to, essentially says that you need to be able to, from the deed you have, to know where to go back, at least if you have to go beyond the root tiles, to know where that record is, some kind of reference that does that, and this really doesn't seem to do that.
Short answer is no, that's not the requirement under the statute nor under the case law in Blackstone and Toth. The longer answer is the reference general or not? If it's general, then we go on to another step and find out whether there's enough specific identifiers. In this instance, it is in fact not general because of the adequate, accurate description of the property interest.
So your rule would be that as long as the property interest is adequately described, nothing else matters. It doesn't matter how difficult it is, as long as they specifically say that we're reserving coal or we're reserving something else.
Essentially, yes. And
doesn't that defeat the purpose of the whole Marketable Title Act?
No. The purpose of the Marketable Title Act indeed is to facilitate or simplify title transactions, but it also, the Marketable Title Act also has the purpose of protecting. There are specific references to protecting interests that predate the root of title. And this court in Blackstone made a specific point of saying that those two interests must be balanced. And that is what this court needs to do, I believe, again, and balance those interests and protect those interests that are accurately described. I say that that reference that is embedded within that 40-year chain of title more than once is a blinking red light here to title examiners who can say there is a reservation of a specific property interest, coal, gas, oil, that I need to figure out what happened, who has that, because what's here, the Morrisons have admitted in the title that they don't own it. They have said on a couple of different occasions that that property, we don't own that. We own the surface. We do not own those minerals. So under Blackstone and Toth, one case said there's no requirement of a volume and page. And the other case said that there's no requirement of a name. And what is required when you look at both cases and you take the sum and the substance of this court's jurisprudence, what's important is that the real property interest is accurately described. And as I said, there's not a tremendous burden on the title examiners. And the purpose of the Marketable Title Act was not to go and get rid of any and all of the burdens of going to check title, especially when there's these blinking red lights. I see that I'm already down to a couple of minutes, and I tried to reserve more, but I'll gladly answer questions or shut up and save my couple of minutes for later.
Okay, thank you.
Thank you.
Mr. Watts?
Chief, he's having technical difficulties. He's going to go ahead and use the dial-in feature right now. I'm going to need to remove his video, though, from the session.
Thank you. Mr. Watts, are you there?
Yes, can you hear me?
Yes, we can hear you, if you'll proceed.
All right. Chief Justice, Honorable Court, my name is Greg Watts, and I represent the appellees, the Morrisons. I apologize for the technical difficulties at the last minute there. This court has already decided in Blackstone, which was a 7-0 decision, that a mere repetition is not sufficient under the Marketable Title Act to preserve a pre-root interest, unless the repetition includes 1, the type of interest created, and 2, to whom the interest was granted.
Well,
the second prong of the Blackstone test is a conjunctive test. because it's separated by the word and so it requires all things in the list. According to Blackstone, the reference must
Can you hear me?
Yes.
That's not what we said in Blackstone, though, was it? We didn't set a bright line rule that always has to include the name.
You're correct. Well, the court declined.
It was sufficient because it did, but we didn't say what you're saying today.
Sure. To answer your question, the court did decline in Blackstone to set a bright line rule, which is generally preferable when it comes to interest regarding real estate. But they did say that you needed a description of the interest plus something else. And the plus something else in Blackstone was the who. They didn't stop at the first step of the test, which is a recitation of the interest itself, which is where the Ericksons, the appellants, would have the court stop here at just a recitation of a prior interest. And again, the court in Blackstone thought you needed more than that. And when they looked at it, they said, well, when you've got the interest plus to whom the interest was granted, that was sufficient. And that's because a reference is only specific if it provides enough clues as to either the instrument creating the pre-root interest or the identities of those who own the interest to properly identify that pre-root interest. The appellants cited in their brief. Yes.
Mr. Brody says that the reference to the first party in that description with the right of first parties. And my question to him was, are those first parties named and identified when this, was when the mineral rights were first subject to severance? And he said, yes, they are. And then he characterizes that phrase or that part of, the relevant language as being what he calls a blinking light to know that a title examiner should look, which, makes sense. And that this is not a heavy lift to figure out, from the root document, what we're talking about. What's your response to that?
Sure, Your Honor. The answer to that is not accurate. First, the first parties does not refer to the Ogles or Ericksons. And secondly, if all you needed was a blinking light, then a general reference would be good enough, but that's not what the Marketable Title Act says. The Marketable Title Act says a general reference is not good enough.
Counsel, yes. What do you think the first parties means? They're first parties, they're heirs and assigns at any time to drill, operate for oil, gas, and to mine all coal. So it's very specific as to what the minerals were or are. What does the right of the first parties, their heirs and assigns mean?
Yes, and in Blackstone, this court said to be specific, the reference has to be accurate, free from ambiguity as results from careless lack of precision or from omission of the pertinent matter. So I would say that reference to the first parties fails on three of those points. First, it omits, the who. It doesn't say, outside of these words, first parties, but that first parties is not accurate. Who is that? The first parties within the general reference refers to the grantors of those deeds. So in this case, in the 1949 root of title in which that repetition appears, first parties would refer to Ross and Mary Morrison and Alta and Edward Riggs. When it's repeated in the 1978 deed, first parties would refer to the grantor Margaret Morrison. In the 1998 deed, the repetition first parties would refer to the appellees in this case themselves. Therefore, it's not accurate. It references the appellees, and it doesn't reference the Ogles and Ericksons. At best, it's ambiguous.
So, counsel, let me ask you this. In 1978, when they bought the property, they would have understood who the party of the first part was, correct?
No, I don't believe so. Again, because it doesn't say who that is. There's no information in that repetition that would tell you the who, where, when, or anything else outside just the nature of the interest itself.
When they bought it, they knew they were not acquiring it, correct?
I mean, it's certainly possible, but again, knowledge is not one of the parts of the Marketable Title Act. Again, it's referencing the root of.
To you is, at the time they're buying the surface, they know they're only buying the surface, correct?
Again, whether or not that's correct or not, I can't opine to their mental state in 1978, but I would say that it's irrelevant.
Okay. I understand you keep wanting to go back to that, but they're executing a deed. They know the reservation's there. Now, the people who actually create the deed after that point in time are them. They're transferring it in their own chain. First, they do a survivorship right in 1983, so they're just redoing their deed to make sure they have a right of survivorship. And then they do it in 1998 into a trust. Does it matter that the repetition is them without the other individuals being privy to it?
No, it does not, and it does not for two reasons. One, when they purport to, put forth the reservation in that deed because it purports to accept and reserve, the 7th District Court of Appeals in a case Covert v. Kuntz would say that quote reservation or repetition was of no legal effect. And in that case, an interest was extinguished under the Marketable Title Act because the reservation or repetition of reservation referred to the wrong party. In that case, the root of title referred to a Thomas, where the original reservation was by a Mooney. And so the court said that, quote, reservation by Mooney was of no legal effect and not effective to preserve the prior reservation by Thomas. And it had no legal effect because it couldn't be reserved as it was reserved previously, again, but then the marketable title would extinguish that. Secondly, again, this thing about them putting it in their own deeds, again, is that knowledge, again, is not part of the marketable title test. In fact, this court in West v. Bode acknowledged that the Marketable Title Act relies heavily, if not exclusively, on the record chain of title. Even the dissent agreed, stating saving events, preserving property interests from extinguishment under the Marketable Title Act must appear in the county land records. I would note that generally, interests are extinguished under the Marketable Title Act regardless of a person's knowledge. 530150 states that subject to the matters stated in Section 49, record marketable title shall be held free and clear of all interests, regardless of any act or transaction or omission, and all interests are declared null and void. None of the exceptions in Section 49 prevent extinguishment based on knowledge. And the court can't rewrite the statute to include an exception where the legislature declined to do so. The Marketable Title Act's panacea or pandemonium in the Cornell Law Review notes that notice is always irrelevant to the extinguishment feature of Marketable Title Acts. The design to simplify can only be accomplished by eliminating as much as possible all matters extraneous to the records, such as the bona fides of any particular individual. And so therefore, when we're looking at the purpose of the Marketable Title Act, it's important to know, while it might not be the sole purpose, it is by far the most important purpose to limit those searches. In the bill analysis for House Bill 81 in 1961, it was noted that the purpose of the Marketable Title Act is to facilitate the marketability of title by fixing a period of time, 40 years, beyond which the title search would not be required. The Miami decision by the Florida Supreme Court, which was cited by Hefner, recognized that the operation of the Model Act was indeed intended to limit title searches. It cited the Marketable Record Title Act and Uniform Title Standards, Section 6.2, which said the chief purpose of the Act is to extinguish stale claims and ancient defects against title to real property, and accordingly limit the time of the the period of the search. Coming back to the Toth decision discussed by appellants, Toth is distinguishable or inapplicable. First, in Toth, the title insurance company did not argue lack of specificity, but rather was trying to argue a plat could not be part of the monuments of title because it itself was argued was not a title transaction. The court held in that case that it was the 66 deed was a monument, and because it referred to the restrictions in the plat by page and volume, it was upheld and not eliminated by the Marketable Title Act. Toth noted that it was nearly a matter of first impression, and Blackstone built upon Toth and clarified Toth by recognizing the three-pronged test. Blackstone is the more recent proclamation on the topic and went to significantly greater depth on the issue. And then in Toth, like I said, it had a page and volume number, so it at least pointed to the what of the setback restrictions and the where. It had a page and volume. The dissent in Toth would have seemed to follow Sims and Taylor, which in the Model Title Act or standards had stated that a reference in a recorded instrument may be disregarded by a person who is not a party to such instruments unless the reference states its place in the public records. The majority in Toth seemed to accept something less, again, the what and the where, which again Blackstone clarified, and in Blackstone they looked at the what and the who. In each case, both courts required more than just a general nature of the interest.
But counsel, they did not require a volume and page.
In Blackstone, correct. Blackstone did not require a volume and page. Blackstone said the nature of the interest and to whom was sufficiently specific.
And do you agree that the interest is described within the chain of title?
The nature of the interest, correct. But that doesn't tell you where the reference is in the pre-root chain. And the chain of title is not served by giving it preserving power. More information is needed in the reference, not less. A general reference just to the interest type, say oil and gas, would be enough. Then the Marketable Title Act would never limit any searches. You'd always need to search the entire chain of title. Plus, it's not uncommon to have multiple different reservations in a chain of title, which could lead to possibly absurd results, where you had that, which again is not uncommon. If there were multiple prior reservations, to which one does it reserve or reference? It would make it no better than having no reference at all. Therefore, the court must apply the Marketable Title Act as it unambiguously provides. The General Assembly did not draft the MTA exceptions in an open-ended matter, but it states the only exceptions and the only preserving events. And I'd also point out, this question about the repetition in the deed and didn't the Morrisons know? Well, again, this manufactured knowledge exception by virtue of the repetition would swallow up 5301.49A and Blackstone. Blackstone confirms that knowledge of a prior reservation through a general repetition does not invalidate applying the MTA to the interest. Rather, knowledge of that prior reservation through that general repetition is the prerequisite for applying the three-part test. There would be no reason to distinguish between general and specific under the Marketable Title Act if knowledge by virtue of the repetition would prevent the Marketable Title Act completely.
But counsel, your client did have knowledge, correct?
Well, see, again, this knowledge, no, my clients were not aware of the appellant's interest. In fact, in this very case, they sued different parties.
Okay, they knew counsel, they knew they didn't own the mineral interest.
Well, they knew from their deed that there was possibly a prior interest, the validity of which I guess would depend on the Marketable Title Act. The recording statute had already created a record chain of title on which persons it could rely, but the legislator wanted persons to be able to rely on a record chain of title as described in 5301.48. And 5301.55 says the Marketable Title Act has to be liberally construed to effect the legislative purpose of simplifying and facilitating land title transactions by allowing persons to rely on that record chain of title as described in 5301.48, subject only to those limitations in Section 49. It's important to realize that unless prior interests are extinguished by operation of 5301.50, a person's ability to rely on the 40-year chain of title described in 5301.48 is no better than if the Marketable Title Act had never been enacted. The extinguishment of prior interests under 5301.50 must be construed broadly, whereas the exceptions to extinguishment under 5301.49 must be construed narrowly. This is the same principle of statutory construction applied in other similar situations. In Buckeye Forest Council v. Division of Mineral Management, it was noted that the mining statutes promote the health, safety, and welfare of people. As such, the statute is to be broadly construed, and the exceptions to the statute are narrowly construed.
Thank you. Thank you, Mr. Watts. You've used your time.
Thank you, Your Honor.
Mr. Brody?
Thank you, Chief Justice. First, I'll note that my colleague did not dispute that the parties and of the first part can be figured out by taking a look at the prior instruments. It's also important to reiterate that there is no test set forth in Blackstone on this. You've got to have something more than a description of the interest. There's nothing in Blackstone that says that. Blackstone's three-part test, the second part, is it or is it not general? That's where our focus is, and the Blackstone test did not include, you've got to have something more than the description and an accurate and of a description of a particular property interest. So that would be adding something to Blackstone. These prior interests are worthy of protection. The court in Blackstone continued to, or made a real point of saying that there needs to be a balancing. Yes, I get the liberal versus narrow construction, but I contend that there should be a liberal construction of specific exceptions that are protecting real property interests, fee interests from extinguishment, especially when there's a blinking red light, and especially when there's a blinking red light that has been attested to, acknowledged by the very parties that are seeking to enforce the Marketable Title Act. Is there an exception for, quote, knowledge? I don't see it. What I see is evidence in the chain of title that these people knew that they didn't own it, and that is not the proper balancing for this court. Thank you so much.
Thank you. Thank you, gentlemen. We will take the matter under advisement and you'll be notified of our decision. All right, our last case this morning is 2020-1206, Disciplinary Counsel versus Christopher James Birchinell. For the respondent, Mr. Matthews.
Good morning, Your Honors, and may it please the court, Mr. Caligari. Your Honor, we'd like to request 3 minutes rebuttal.
proceed.
This is a case, if it please the court, where the court can pronounce how mitigation will be weighed against serious misconduct. And there is serious misconduct in this case. We expect that Relator will remind you of that. However, when there's serious misconduct and there's also significant mitigation, will you still impose disbarment, or will you impose an indefinite suspension? We would suggest that an indefinite suspension is warranted in this case, and we set forth a two-part argument. First, the board erred when it stated that the public cannot be protected except by disbarment. As the court is aware, the indefinite suspension has significant protections. There's a process that must be gone through, and we want to talk about that. Secondly, Mr. Birchinow's misconduct notwithstanding, if the point of the Ohio lawyer disciplinary system is to protect the public, which is what we say it is, and not to punish, he should be given another opportunity at rehabilitation. And Relator will certainly remind you this is Mr. Birchinow's second strike, to use the baseball analogy. This is his second strike, but we believe he should be given another chance. As to the first point, at page 9 of Relator's brief, Relator says the public, and this is a pretty bold statement, the public is endangered by an indefinite suspension. And we would respectfully disagree with that for a number of reasons. Number one, Mr. Birchinow made it quite clear during the hearing when he testified, and by the way, he is the only witness who testified in this case. He did not call Relator to task to put forth any witnesses against him because he stipulated to over 200 paragraphs. He stipulated to many violations. He stipulated to over 100 exhibits, and he took responsibility and owned his conduct, which is important, and we will talk about that. So Relator's suggestion that an indefinite suspension endangers the public in this case misses the point. The public is endangered by indefinite suspension with a lawyer who does not take responsibility, a lawyer who taxed the system by not paying restitution. And in this case, the important mitigation of paying restitution and taking responsibility for his misconduct does exist in this case. Moreover, if you look at Rule 5, Section 25, which is the petition for reinstatement rule, and we talked about that in our brief, there is a minimum of 2-year suspension. Mr. Birchinow was very open in suggesting that he knew that he had an uphill battle, and if he ever got to practice law again, it wouldn't be anytime soon. So he knows he's got a lot of work to do. Importantly, he did reach out to the Ohio Lawyers Assistance Program, and that work has begun. And Relator went through great measure in this case to attack that participation with OLAP. As the court is aware, because you refer many lawyers to OLAP, when a lawyer goes to the Ohio Lawyers Assistance Program, that particular lawyer has some issue. It's either a mental health issue or a substance abuse problem. And so participation is not going to be perfect, and it was not perfect in this case. However, Mr. Birchinow has worked with OLAP in the past. He did that after his first case, and he did so successfully. And we believe that that should be given significant consideration in this case. Back to Gov Bar Rule 25, it requires at least 2-year suspension, and then the petitioner has to demonstrate by clear and convincing evidence that that particular lawyer is qualifies for reinstatement, the petitioner must show that he's made appropriate restitution to persons harmed by his misconduct. That's already been done here. The petitioner must show that he or she possesses all of the mental, educational, and moral qualification that were required at the time of admission. And that's where respondent understands he has to do a lot of work in this case, if given the opportunity. The petitioner must show that he or she has complied with the order of suspension. The petitioner must show that they have complied with their continuing legal education requirements. The petitioner must complete a term of probation or community control if there's a criminal case like there was involved in this case. That must be done. And so protection of the public is not at risk by an indefinite suspension in this case, given all of these requirements that have to be met. And we understand that these requirements in this case would be significant. Importantly, and this goes to our second argument, the board suggested that rehabilitation was not appropriate in this case. In other words, suggested that because of the gravity of the misconduct in this case, the respondent could not be rehabilitated.
Are you sure it was based on the gravity or on the recidivism of his activities?
That's a good question, Your Honor. There was recidivism in this case. And so it was not only the activity, but probably also the recidivism. And we understand in this system that unfortunately, sometimes respondents engage in misconduct, and then sometimes they engage in misconduct again. One important consideration in this case, Your Honor, we would respectfully suggest that this particular respondent has actually got a track record of working well with the Ohio Lawyers Assistance Program. And, you know, for 4 years, he was engaged in a counseling relationship. And unfortunately, his counselor retired and he didn't re-engage with another counselor. And his OLAP contract ended. And he didn't remain, he didn't continue to do the things that kept him out of trouble, and unfortunately got in trouble again. But you're right, Your Honor, recidivism is an issue. It's an aggravating factor. And so that has been considered in this case.
Counselor, let me ask this to you. What do you feel are the strengths of mitigating factors to counteract those aggravating factors? I mean, his recidivism started within a couple of years after his agreed contract, and it shows that unfortunately his OLAP time wasn't successful, and the misconduct escalated. So what would give this court the belief that allowing the opportunity to once again seek assistance would still protect the public when he's shown that given the opportunity to do so, he was unable to do so?
You're right, Your Honor. Those factors that you've outlined certainly weigh against him. I would suggest that it wasn't a couple of years after he relapsed, but it was actually 7 years from the time that of his first misconduct, and then he was with OLAP for 4 years, and then there were 3 years when he was not counseling. And then in 2016, that's when the misconduct began again. And at that point, he had gone through, a painful divorce, and he had significant medical issues, which led to the financial problems. And again, that's not to make excuses, but I'm just outlining the facts as they existed. But to your question about what are the strong mitigating factors here, as the court is aware, there are many lawyers who don't engage in the process. They receive a complaint and they ignore it. And that's really bad for the system because, restitution doesn't get paid, client grievances don't get answered. And so there are so many lawyers who default in this system. So he actually—
Sorry to interrupt, but didn't he ignore some letters of inquiry and some calls?
Well, Your Honor, that was at the beginning of the complaint, and that is listed at an aggravating factor in this case, his lack of cooperation initially, but the parties actually stipulated that he cooperated post-complaint. So his post-complaint cooperation was very good, and that's what I'm pointing to here. Wouldn't
the complaint have been delayed because he didn't respond properly to the letter of inquiry? In fact, I think there were a couple.
That's true, Your Honor. That does burden the system. It does make disciplinary counsel's job harder when the complaints are not answered immediately. And so that did exist in this case. However, post-complaint, and this is where it's really important for the board that when that complaint is answered and a respondent actually participates and a respondent actually engages and answers the questions, hires counsel or not, but participates in the system, that is extremly significant. So that's number one. Number two,
and he did that with OLAP for 4 years, right? But then didn't I read somewhere he didn't go back to OLAP till 2 days before the disciplinary hearing?
Okay, so that is what disciplinary counsel, and that is another mitigating factor to go to Justice Stewart's question, his engagement with OLAP. What disciplinary counsel was suggesting is that his engagement with OLAP was not good, that it was not consistent. And, you know, we respectfully suggest that, number one, we proved through OLAP's testimony that he was in counseling the whole time, okay? He was working with a counselor, but his work with OLAP was not as consistent as it might have been. And so that was a problem, Your Honor. And we agree that is certainly a strike against him, that he engaged with OLAP, but it was not the type of engagement that we could have actually proved, you know, that the nexus of his conduct, et cetera, through his counselor. So the other point that I wanted to make to Justice Stewart's question is restitution. The disciplinary system is significantly taxed by lawyers who do not pay restitution. Those claims are turned over to the Lawyers Fund for Client Protection, and they're oftentimes not paid. And this particular respondent paid restitution. And I think that sets him apart from many of the lawyers involved in the precedent cited by both the board and relator. He paid restitution. He paid the most significant restitution in connection with the criminal case. And then there was another client at the end that he paid the restitution right immediately before the hearing. The point is that he engaged in the system, he participated, and that's much different from lawyers who ignore the system and tax the system and cause all kinds of expense to the system by not paying restitution, not participating. He did that, and that separates him from lawyers who don't. Those lawyers who don't should be disbarred. But when you do engage, you should be given an opportunity. Yes, Your Honor.
Mr. Matthews, how did he make restitution to the client, the former client who is in prison and whose brief wasn't filed? And the appellate brief, how did he make restitution there?
I don't believe that any money was paid in that particular case. I believe that was a court-appointed case, Your Honor. I know that all of the restitution that was owed in this particular case was actually paid. So the case that you're referring to, Your Honor, I believe was a court-appointed case.
But was his appeal ever heard?
No, Your Honor. No, I mean, at least I don't believe that it was, and that client was certainly harmed. So your point is well taken on that one. And that certainly weighs against him. We're not suggesting that he's blameless here. We acknowledge all the misconduct. If you look at his testimony from pages 68 through 173, he owns his misconduct. Now, relator will stand up and tell you that that was insincere. Relator's counsel's a great lawyer. I don't think he has superpowers of mind reading.
Mr. Matthews, what else could your client do but own it?
Well, Your Honor, that is true. I mean, I get your point that what else is he to do?
I mean, he could have, his whole, reading the report, the page upon page upon page of lies that your client told everybody at every turn, unashamedly, to the point he certainly can't duck that. He can't duck the fact that he didn't attend to their legal problems. He can't duck the fact that he failed to file an appellate brief for someone who was counting on him. So, I don't give him, a lot of credit for owning anything.
Well, Your Honor, I believe the requirements of mitigation certainly suggest that lawyers are given credit for owning their misconduct. And in this case, and you've seen plenty of cases, Your Honor, and you certainly hold it against the lawyers when they don't own their conduct, when the conduct is very apparent and they make excuses. And if you read respondents' testimony in this case, which I'm sure you have, you will see that there are no excuses that are made. And nor did he call relator to task to put forth a single witness other than himself to prove relator's case. So in this particular case, we would encourage you to look at that, to look at his engagement, to look at the fact that he took responsibility. You're right, Your Honor. The evidence was clear. He, apparent, he should have owned it, but he did. And there are many respondents who don't. We would like to reserve the rest of our time for rebuttal.
I'd like to ask one more question. So
yes, Your Honor.
You realize a post-conviction motion for ineffective assistance of counsel cannot be filed by appointed counsel, don't you? So it means that the client who's in prison who didn't get his appeal filed has to either file a post-conviction motion pro se or pay for counsel himself. Does your client realize that?
I'm not certain that he did, Your Honor, and your point is very well taken. And those clients deserve better. And Mr. Birchenow indicated that in his testimony, that he apologized to the relator, he apologized to the board, he apologized for the bad practice. He apologized for those things, Your Honor.
Thank you.
We'd like to reserve the rest of our time for rebuttal. Thank you.
Thank you. Mr. Caligiuri.
Thank you. May it please the court, Chief Justice O'Connor, distinguished members of this court, Mr. Matthews. I'm Joe Caligiuri and I represent the Office of Disciplinary Counsel on this matter. Before I get into my argument, I would like to address a few points that my opposing counsel made. The first has to do with mitigation. And Mr. Matthews characterized the mitigation in this case as significant. And the reality of it is that there is no significant mitigation in this case, which is why, coupled with the gravity of the misconduct, recidivism, that relator is asking the court to adopt the board's recommendation and disbar the respondent. Even the mitigation that the respondent does have, which is the imposition of other penalties, a 10-day prison sentence for his felony conviction for theft, and post-complaint cooperation. Justice Fisher was correct. He didn't cooperate at all during the investigation of these multiple matters. He did come around after the complaint was filed. But even that mitigating factor bears little weight in this matter, because while this case was pending, the respondent committed additional misconduct, which forced relator to amend the complaint. So while this case was pending, the respondent reneged on a promise between himself, relator, and the panel chair to go inactive by September 1st, 2019. He reneged on that promise, and then he went into a court of law who happened to be aware of the fact that he had made this agreement through the online docket, and he lied to a judge, stating that the agreement was to wind down his practice by October 1st, when he knew that it was September 1st. The second point is that he committed additional misconduct when he suffered an attorney registration suspension on November 1st, 2019. He continued to practice law under suspension, and when another judge in a different court called him on that, he again instantaneously defaulted to this deception, deceiving the judge, making him believe that the respondent had submitted his application to the Office of Attorney Services and that they hadn't properly processed their application. So he impugned the integrity of the Office of Attorney Services when he hadn't even filed his application for reinstatement, for registration. And so this is someone that was willing to lie while his own disciplinary case was pending. And what makes it even worse is that he was under the care of an OLAP contract in counseling at that time. So respondent's behavior proves to this court that he is incapable of conforming his behavior to the ethical standards that we require of lawyers. The second point in relation to Justice Bruner's comment on recidivism, that's a huge aggravating factor in this case. It's not just that the respondent has previous discipline. We've seen a lot of cases where lawyers have previously disciplined but are not disbarred. The issue here is that his previous discipline was for the same type of misconduct: stealing money, lying to clients, and failing to cooperate in the underlying disciplinary investigation. He goes under the care of a psychologist and social worker. He gets a healthy prognosis to return to the competent ethical practice of law. And within 2 years, he's escalating, as Justice Stewart said, he's escalating his misconduct. And now he's stealing from a client who he has declared incompetent. So we already know that that rehabilitation is not an option in this case. We have been down that road before. Ultimately, there are 3 reasons why we would ask this court to adopt the board's recommendation and disbar the respondent. The first is that the respondent possesses a fundamental lack of integrity. His pervasive pattern of dishonesty and deceit exposes a deeply flawed moral character, which strongly suggests, as I stated before, that he's incapable of conforming his behavior to the ethical standards incumbent upon attorneys in our state. The second reason why you should adopt the board's recommendation and disbar the respondent is that his conduct in this case, the misconduct, implicates 3 separate presumptions for disbarment. And the little mitigation evidence that he has is simply insufficient to overcome even one presumption, let alone all 3. And the third reason why you should accept the board's recommendation is that disbarment is the only mechanism to ensure that the public will be protected and that we can preserve the integrity and maintain the public's confidence in the integrity of our profession. Mr. Matthews states that it's relator's position that an indefinite suspension would endanger the public. That's absolutely correct. And we have respondents' past behavior to indicate to us that he will be, if he is reinstated, he potentially will be a danger to the public because we've been down this road with counseling and it hasn't worked.
Mr. Caligiuri?
Yes.
So OLAP initially dealt with substance abuse, especially alcoholism, and it was later enlarged to deal with mental illness. I don't believe it's dealing with trauma or head injuries, and those have been shown to cause people to exhibit symptoms like impulsivity, which oftentimes is manifested in lying. If we get 20 years down the road and OLAP is dealing with those issues, and those ended up having to be issues that weren't dealt with in the current OLAP process, and do you think that we would be in good shape by disbarring him now rather than an indefinite suspension where we have the ability to say no unless and until maybe those issues were dealt with. I'm not trying to diagnose him here, but I'm just pointing out where the literature is leading and where I've seen it go over the last 20 years.
Well, Your Honor, I think the difference in this case is that we have evidence of his previous conduct. We have evidence of his attempts at rehabilitation, and we now have somebody who is minimally participating with OLAP at best. During a 5-month period under his current OLAP contract, he had a 3.3% check-in rate. He checked in 2 times out of a potential 60 that he was required to do. So he's not committed to his OLAP recovery. But the issue with respondent and why I would be cautious with an indefinite suspension is that he is a master manipulator. He will say and do anything in the moment to extricate himself from a situation, as evidenced in every single count of this complaint, the 7-count complaint. And so it wouldn't be beyond the possibility for him to be able to get a prognosis from a psychologist or a psychiatrist that he is fit to return to the competent ethical practice of law, just like he did in 2014, and simply start engaging in the same type of behavior again. If there was some issue with his physical ability to practice law, we may have pursued a different course of action, but there is no evidence of that. He brought no evidence to the table regarding his underlying mental condition. In fact, he waited 14 months from the time he was diagnosed, from the time that he signed his OLAP contract to even provide OLAP with a diagnosis from his treating social worker, Dr. Ruth, which wasn't even put into evidence in this matter. And he did that 2 days before the hearing. So I think leaving the door open in the hopes that maybe there's some potential of diagnosing some other problem, I think overlooks the gravity of the misconduct, the depth of this dishonesty, and the length of time this has been going on.
Thank you.
With regard to my statement regarding his flawed moral character, this court really doesn't need to look beyond count 1 to understand this. In count 1, the respondent exploited his client, Bradley Collins, who he had been appointed to represent in several felony matters. In that particular case, almost immediately, the respondent realized that his client was vulnerable and that he was potentially not competent to assist in his own defense and stand trial. So upon the respondent's own motion, he asked to have his client declared incompetent, and in the motion in Exhibit 5, he states that his client was delusional and out of touch with reality. At the same time, he starts to misappropriate funds from Mr. Collins, first through the context of a quote-unquote loan, and then once his client was institutionalized, he systematically misappropriated what amounted to a total of $41,300 from an incompetent client who, when he was institutionalized, placed his trust in Mr. Birchinall to take care of his bills. And what Mr. Birchinall did was have him sign blank checks, and then Mr. Birchinall would write investigator to convince him that he was hiring an investigator for his client's criminal case when he was simply siphoning the money right out of Mr. Collins' account. So the depth of dishonesty just in count 1 is astonishing. And then when he went to repay the funds, he presented him with a $5,000 check, which was drawn on an account that Mr. Birchinall only had $1,000 in. And of course, the check bounced. Then he tried to con his incompetent client into accepting 2 vehicles as partial payment for the restitution. And when his incompetent client said, well, I need the titles, the respondent had to admit that he didn't have title, that the bank owned the vehicles. They were encumbered. So he quashed that attempt to make restitution. And ultimately, he did pay the money back in that case, but he was also under criminal indictment, and he had to get that money paid back. or it's very likely his sentence would have been enhanced. And the other issue with respect to count one is that in addition to trying to con his client, when the respondent made restitution in that case, as I stated, he was under criminal indictment and his back was up against the wall. Right? But this was a client who thought Chris Birchnell was his friend. He trusted him, and the respondent obliterated that trust. And so when the respondent comes in today and says he should be given credit for mitigation, we must realize that mitigation must be timely and it must be born out of good faith. Here, in every case, the three matters where you yield restitution, it was untimely in every one. 2 years with Collins, 3 years with Poole, 6 months with Riley. And it was born of bad faith, as evidenced by what I just said, how he tried to make restitution to Mr. Collins with the fraudulent titles and the $5,000 bounce check.
Mr. Caligiuri, but as Mr. Matthews stated, is it your belief that there is no treatment, or there are no, treatments, plans, conduct, learning, education, etc., that could ever bring Mr. Birchnell up to the level of being able to be trusted in the practice of law again sometime in the future, or at least have the opportunity to with an indefinite suspension?
Well, I personally don't feel that Mr. Birchnell is capable of rehabilitation, but I will admit that we don't have the evidence from an expert to say that he is or he isn't. There's always some possibility, I suppose, that lawyers can be rehabilitated, but we have to balance that with the misconduct that has occurred in this case and his previous case. Again, there's just simply no room in our profession for lawyers who lie, like Mr. Birchnell lies. He is a pathological liar. Even the board characterized his pattern of lies as quote unquote almost pathologic and quote unquote almost unbelievable. That's the impact that he had on the panel when looking at this misconduct. So while there may be some hope for rehabilitation in the future, our best indicator of what the future will hold is looking at his past practice. He's obtained counseling from OLAP in the past. It didn't succeed. He signed an OLAP contract in the middle of this proceeding and he hasn't complied with it in the least. And he committed misconduct while he was under the OLAP contract and while this complaint was pending. So his past behavior is our best indicator of what he'll do in the future.
Thank you.
You're welcome. And finally, with respect to my statement that disbarment is truly the only mechanism to protect the public, this gets back a bit to the recidivism issue. Again, the respondent has been disciplined for the same type of misconduct. The only difference is that the misconduct in this case was much more egregious. He harmed more people. He stole more money. He lied to more people and he told more lies. So there's no reason to believe that an indefinite suspension will adequately protect the public. And as this court said in Disciplinary Counsel versus Calabrese, it said, although the board recognized that the primary purpose of discipline is to protect the public and not to punish the offender, the board noted that there are times when to maintain public confidence in the legal profession and to preserve the integrity of our profession, the imposition of the ultimate disciplinary sanction, that is permanent disbarment, is appropriate. And this is one of those times. As I stated, there's simply no room in our profession for a lawyer who lies the way Mr. Birchnell does in a profession that's grounded on truth and integrity. So I would ask that you adopt the board's recommendation, overrule the respondent's objections, and disbar him. Thank you.
Thank you. Mr. Matthews, you may take a minute.
Thank you, Your Honor. Your Honor, this notion that there is no significant mitigation just is not correct in this case. The parties stipulated to 7 mitigating factors, 5 aggravating factors, 2 mitigating factors. However, at that point, the respondent had not testified, and he did testify, and relator must acknowledge that testimony did take responsibility for the misconduct, which, you know, as Your Honor pointed out, is he should have, but we know that many lawyers don't, and he should be given significant credit for that. And that does go to integrity. People who lack integrity don't take responsibility, and the respondent took responsibility in this case. Moreover, restitution, although it was not timely, was made in this case, and that is significant. This system is significantly taxed by lawyers who don't pay restitution. We would suggest that this lawyer should be given an opportunity to apply for reinstatement at the appropriate time. And at that point in time, we do believe that the court should require a competent mental health professional to testify regarding his ability to competently, ethically, and professionally practice law. That certainly should happen. And he shouldn't be reinstated until that happens. That is an extra protection that this system allows, and we believe that that should be imposed in this particular case. That he must fully comply with an OLAP contract, and that he must get the proper counseling to show that he can ethically and professionally practice law. Thank you, Your Honors.
Thank you. We'll take the matter under advisement. You'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.